Welcome to the deep dive. Today we're tackling something really specific, but super important in criminal law. Recidivism as an aggravating circumstance.
All right, we're looking at paragraph 9, article 14 of the revised penal code.
Exactly. We want to know, when does the law officially say, okay, this person is a repeat offender, and what does that actually mean for sentencing?
And it means quite a lot. The law views recidivism as, well, the term used is greater perversity. It implies an increased tendency towards crime.
Greater perversity. It's strong language. It suggests the law sees it not just as another mistake, but as a deeper pattern.
Precisely, which is why it acts as an aggravating circumstance, potentially increasing the penalty. So understanding the exact definition is critical.
Okay, let's get into that definition then. What's the actual legal test? How does the system decide if someone fits this category?
It's very strict. Basically, a recidivist is someone who is on trial for an offense.
Okay.
And they have a previous conviction by final judgment.
Judgment. Got it.
For another crime that falls under the same title of the revised penal code, the RPC.
Ah, the same title rule. That sounds like the key classifier here.
It really is. So think about it like categories. If someone was convicted of theft and is now on trial for a robbery.
Both are under Title 10, crimes against property.
Exactly. So that could establish recidivism, assuming the first conviction is final. But if the prior conviction was, say, physical injuries.
That's Title 8, crimes against persons.
Right. And the current trial is for theft, Title 10. Different titles.
Yeah.
So under this specific rule, that wouldn't be recidivism.
Okay, that makes sense. It keeps the focus on repeated behavior within the same sort of criminal activity. But you mentioned timing. How does that play in?
Well, this is where it gets particularly interesting. The general rule focuses on the time of trial.
Meaning the period from arraignment through to sentencing.
Yes, that whole window. If the prior conviction becomes final before the judgment in the current trial, recidivism generally applies.
But there's a twist, isn't there?
A
Supreme Court ruling.
There is a really important one, actually. People v. Baldera. It introduces a sort of chronological check.
How so?
It says that even if you have a final prior conviction at the time of the current trial, recidivism doesn't apply if the offense in the current trial was actually committed before the offense in the prior conviction.
Whoa, okay. So the actual order the crimes were committed matters, not just when the courts process them.
Exactly. The sequence of commission is crucial. It prevents someone from being labeled a recidivist based purely on, the potentially random order of court dates.
That's a huge detail for a defense, I imagine. You'd need to pinpoint the actual dates of the alleged acts.
Absolutely. Now, another boundary to consider is jurisdiction. Does a conviction for violating, say, a city ordinance count?
Good question. Or special laws outside the main RPC?
Generally, no. Recidivism under Article 14 is mostly limited to RPC offenses. So a prior conviction for illegal gambling under a special law, like in the Lawlico case.
Wouldn't usually trigger recidivism for a later RPC crime like theft or homicide.
Correct. And we mentioned finality earlier. That's non-negotiable. The prior conviction must be final.
Meaning the appeal periods have passed or appeals are resolved.
So if someone gets convicted of 2 different crimes in judgments handed down on the exact same day.
Neither is final yet. The 15-day appeal clock is still ticking for both.
Precisely. So one can't be used to aggravate the other under the recidivism rule at that moment.
And unlike some things in law, there's no time limit. If the prior conviction was decades ago.
Nope. Decades could pass, but if the conditions are met, same title, final judgment recidivism can still apply. It doesn't just fade away with time.
Okay, that leads to the big question about second chances or perceived second chances. What about executive clemency? Like a pardon, does that wipe the slate clean?
Yeah, a very important point. And here we absolutely have to distinguish between 2 types of clemency.
Okay.
First, there's pardon. A presidential pardon, as discussed in cases like U.S. v. Sotelo, relieves the punishment, but it does not erase the historical fact of the conviction for the purpose of recidivism.
So even with a pardon, the court can still consider that prior conviction when looking at recidivism for a new offense.
That's the interpretation. The pardon affects the penalty, not the underlying legal reality of the conviction itself in this context.
But then there's amnesty. How is that different?
Amnesty is much broader. Under Article 89, amnesty is seen as obliterating the offense entirely. It extinguishes the penalty and all its effects.
All its effects?
Yep.
Meaning it does wipe the slate clean regarding recidivism.
Yes. Amnesty essentially provides a complete legal forgetting of the offense. So it removes that prior conviction from the recidivism calculation.
Wow. So pardon limits the punishment, but amnesty removes the offense from the record for these purposes. That's a night and day difference legally.
It truly is.
So wrapping this up, we've seen that whether someone is legally considered a repeat offender under this specific rule isn't straightforward. It really depends on these fine details.
Absolutely. The title of the crime in the RPC, the precise timing of commission versus trial, the finality of the prior judgment, it's all incredibly technical.
And that difference between pardon and amnesty adds another layer of complexity.
Definitely. So here's something to think about. If amnesty offers that complete legal reset, erasing the recidivism factor, while a pardon doesn't, how might that influence legal strategy?
Yeah, especially if someone is facing potential future charges. Choosing which form of clemency to seek, if available, could have massive long-term consequences based entirely on this distinction.
It forces a really deep consideration of not just past actions, but potential future legal standing. It's a fascinating intersection of law, punishment, and rehabilitation.